deposition. Sorry, hold on, Your Honor, I got to pop up. I apologize. We did offer the date of January 3rd of 2023 for the deposition of Dr. Einhorn. We believe that the deposition will go forward on that date. Scott did contact our office and ask that we do an order by agreement. Unfortunately, I do not have the authority to agree to his proposed order by agreement for the deposition to be conducted on that date, but we did offer January 3rd of 2023 for Dr. Einhorn's deposition in this matter.
All right, Mr. Berger, why do you need an order?
This deposition has been noticed twice, canceled unilaterally twice by the defendants. They gave us a date on last Friday. We want an order to make sure this deposition actually occurs the third time it's noticed in this case.
If I could just speak to that really briefly, Your Honor. We recently entered for Dr. Einhorn in this case. I can tell you that I believe that the deposition was previously noticed by her prior counsel. We had no involvement in getting that prior deposition scheduled. Unfortunately, the date that prior counsel had chosen for her deposition, we were unavailable on and could not move forward on that date.
Is that on both deposition dates or one deposition date?
If it was noticed prior to the September date, we also had no involvement in getting that scheduled.
Okay. I don't see the need to enter an order at this point, given what Ms. Mannings has represented, notwithstanding the unilateral cancellation. So I'm going to deny the motion to compel. Ms. Mannings, certainly, these cases need to move forward. This is a 2022 case for keeping the program on track as reasonably as we can. The medical malpractice, I think you may be aware, we are working diligently on keeping those cases as best we can on track, and we've designated Judge Schulman as our medical malpractice program leader. But I don't, accepting your representation that that's a good date and that there's no reason that you can foresee canceling it, then I'll accept that and I'll deny the motion. Okay, good luck, counsel. Nice to see you both.
Thank you, Your Honor.
What about the other motion? Was that worked out on Riley, Papa, and McQuinn's, the other ones?
Yes, Your Honor, that was actually entered by agreement because, again, similar issue entered by agreement, depositions having been noticed before, canceled before, and now finally getting an order for that.
Understood. Okay, good luck.
Thank you, Your Honor.
Counsel, you'll get a notification of your order. Next case, Your Honor, is case number 8. Case number 8, the Schwartz. Will the move-in identify yourself for the record and who you represent?
Sure. Yeah, good morning, Your Honor. My name is Matt Decker. I'm counsel for the defendant moving in this matter, CSX Transportation, Inc.
Respondent.
Good morning, Your Honor. David Lockhart on behalf of the plaintiff, Mr. Schwartz, Adam Schwartz.
I'm sorry, Pete, which number is this?
This is case number 8, Your Honor.
All right. That is Schwartz, you said?
Correct.
Okay.
If I may, Your Honor.
Of course.
Okay. This is just briefly by way of a very quick background. This is a FELA railroad injury case. The plaintiff was a mechanic who alleges he developed some injuries to his shoulder over the course of a multi-decade career on the railroad. We're here today seeking a protective order that is fairly narrow in scope and just seeks to impose a single condition. So we responded to plaintiff's discovery, and there were certain documents that were internal CSX documents related to things like employee safety and operating rule books, things of that nature. So we proposed a draft confidentiality order simply to limit the use of the documents to this litigation and impose the condition that plaintiff's counsel would not disclose the internal company documents outside the confines of this litigation. And we
Are they protected secrets or some confidential business information? What's the value of what's the importance of these documents?
Yeah, so we haven't made the argument that they are necessarily all trade secrets, although I think some of them likely do classify as such. The argument here would be that our concern is for the privacy of the documents insofar as Plaintiff's counsel has compiled these in other cases and has even produced some CSX documents to us in this case that he's received in other cases. So I guess it's more of a privacy concern here that CSX's internal company documents could be compiled and used in other litigation, in other jurisdictions and other matters as sort of an end run around the rules of procedure in those cases.
All right, Mr. Lockhart.
Briefly, Your Honor, there's been no showing of that they've met a burden of good cause, no clearly defined injury. If I'm producing their documents to them, I don't know why they would need an order in this case that those same documents are somehow protected. No specific examples of harm, no delineation of which specific documents, no supporting affidavit, no evidence that there's that they've met their showing of good cause. So there's absolutely no reason for it. And quite frankly, we did this kind of litigation for 30 years with other law firms. Dwayne Morris comes in and they've got a standard operating procedure, which is to ask for a confidentiality order in all cases. Simply no reason for it. Enough said.
All right, so I'm going to deny it without prejudice. If you are able to meet that hurdle with some affidavit or some other subsequent motion, then I'm going to give you that ability, but I don't see the any basis to enter the order as you've described it. Okay.
Thank you,
All right.
Ron.
Thank
Good luck.
you.
Nice to see you both.
Right, take care.
You'll
Take
get
care.
the notification of your order.
Thank you.
Next case, Your Honor, is case number 21. Hannah versus Concept Golf, case number 21. I'm going to ask the movement to identify themselves for the record and who they represent.
Good morning, Your Honor. This is Dave Langsam on behalf of the plaintiff estate of Justin Regal.
Respondent.
Good morning, Your Honor. Glenn Campbell of Post and Shell on behalf of defendants Concert Golf Management, FC Golf GP2, Concert Philmont, and Concert Golf Partners Holdco.
Counsel.
Michael Roush of DC Mahoney and Valentini on behalf of defendant Comprehensive Golf Solutions.
Counsel.
Andrew Cassidy on behalf of Shriner Tree Care Specialist.
All right. I'm first just trying to find your order.
Case number 21.
Yeah. There it is. Okay. All right, so is it, Mr. Langsam, is it the document discovery or is it the depositions that, or both?
So it was both, Your Honor, but fortunately we were able to work out most of this. There is a small portion, however, that we just needed to present to the court.
So let's focus on the small portion.
Sure, sure. So on the second page of the order, there are 8 identified witnesses, and of those 8, we have agreements as to 4 of them. The 4 for whom we don't have agreements are Matt McAllister, Anthony Johnson, Peter Nanula, and David Heiser. And the common thread among those 4, Your Honor, is that they are all witnesses that are going to be produced by Concert Golf. And my friend Glenn Campbell and I worked out dates for those witnesses and others that aren't part of this motion. But unfortunately, last week, Glenn learned that the carrier made a decision to pull this case maybe from him. And even though we had spent all this time trying to get these depositions lined up, he's not in a position now to enter the order by agreement as to those 4 people. And my view is if the carrier wants to make the awful decision to pull this file from Glenn Campbell, then they should do so knowing that these witnesses have already been agreed to be produced on a particular date or dates. And at this point, we just need to get this one moving. You'll hear from Glenn that we have a discovery deadline in August. And from his perspective, that means we have time. But from our perspective, Your Honor, this is the first phase of testimonial discovery. We've got quite a bit to do. I do not want to be in a position where we have to navigate schedules getting into the summertime and then need to come back to the court and say, oh, we need more time because we've identified all these other things that we need to do.
All right, Mr. Campbell?
Yeah, Your Honor, as Mr. Langsom has indicated, he and I did discuss dates for these depositions and others that they had requested. I was in the process of reaching out to the witnesses to coordinate dates. I learned last Wednesday that the carrier for my clients wants to pull the file and send it to somebody else. My client's not happy. They're trying to work through it, but I'm in the unfortunate position of not being able to agree to dates for witnesses because I don't know if I'm going to be on the file. If I'm still going to be handling it, I have no problem agreeing to dates. Like I said, I was in the process of actually lining up witnesses. I have 3 out of the 4 that he's requested. I have dates for those. I just can't say that whoever's going to be taking over this file would be available those dates. So I can't agree to an order that sets dates so that if that counsel's not available, then, we're right back here in court. And as Mr. Langsom's indicated, we have an August of 2023 discovery deadline. And it's curious that he's taking the position that there's another phase of discovery in this case. This is actually the second lawsuit that's been filed by the plaintiff for this accident. In the first, they made a representation to the court that there were only 5 depositions they needed. So now they've now asked for about 12, and I'm understanding now there may be more. So I'm not exactly sure where plaintiff is going with this case, but from my perspective, I can't agree to specific dates for these witnesses, not knowing whether there's going to be an attorney involved who will be available on those dates. So what I had proposed to Mr. Langsom is that we have an order that states that these witnesses will be produced by January 31st, 2023. He won't agree to that. So, and I can't agree to an order that has specific dates for the witnesses. So that's sort of the situation, Your Honor.
Yeah, I mean, as with the last case, or I guess 2 cases ago, I don't see a reason to enter the order as it's presented by Mr. Langsom. I would entertain, Mr. Campbell, if you present the order, which is different than what you've provided, and identify that they should be produced by the January 31st date, that respects your client's desire to potentially move the matter. I hope that they don't. You can advise them. It doesn't seem changing horses in midstream probably doesn't seem the smartest idea, but that's certainly up to them if they wish to do that. And it also protects Mr. Langsom's concern that these witnesses will be off the schedule and therefore not produced timely. And I think two of the 4, Nahula and Heiser, were in January anyway. So Mr.
Right.
Campbell, send the order to Pete and review it with Mr. Langsom, and I'll enter that order today. Okay.
Thank you, Your Honor.
All right. Good
Thank
luck.
you, Your
Nice
Honor.
to see you all.
Thank you.
Counsel, again, just email me.
Your Honor.
We'll get it down to the judge for review, okay? Thank you, counsel.
Thank you, everybody.
Thank you.
Next case, Your Honor, is case number 17. The McDonald matter. Case number 17. I'm going to ask the move-in to identify yourself for the record and who you represent.
Good morning, Your Honor. Daniel Craig. I represent the move-in and plaintiff, Mr. McDonald.
Respondent.
Good morning, Your Honor. Daniel Mulligan, defendant Amtrak.
Good morning. So this was rescheduled from last week. What have you agreed to, and what's left for me to decide?
Yes, Your Honor. So in an effort to narrow the topics on the corporate designee notice, this past week, I sent defense counsel a revised notice attempting to narrow in scope some of the topics of inquiry. In response, defense counsel sent another revised notice where they attempted to further narrow some of the topics. I could not agree to the topics as narrowed as sent by defense. This morning, in an effort to try and streamline this process, we sent an email to defense counsel essentially agreeing to only produce a corporate designee for 2 of the topics, and for all of the remaining topics, we converted those to requests for production, therefore allowing defense to simply produce any responsive documents and only produce a corporate designee for those 2 topics. Now, we have agreed, defense counsel and I, for a corporate designee for those 2 topics, so that's not an issue. I think what's at issue really now is the extent of the topics as they are now requests for production. I believe defense still has some objections as the way that they're phrased. We believe that, the way that they're phrased is completely proper for this case. So that's kind of where we stand.
All right, Mr. Mulligan?
Yeah, as Mr. Craig said, we don't have issues. I think there was very minor revisions to the language of one of the two topics for a designee notice. And as Mr. Craig said, he's correct. As Your Honor requested, he sent a revised notice for a designee last, I believe, Wednesday or Thursday. I redlined it. And on Friday, we were advised that, our red lines were, bottom line, not really acceptable. Around 8:45 this morning, I got an email from the other Dan saying, hey, we can convert this into a document request. Obviously, this is a motion to compel a corporate designee. A document request is a separate discovery procedure. And I just said, if you want to serve your request as a document request, feel free to do so. And I'll review it and respond or object in the rule as the rules permit. But I think there was an issue with, he's hoping to get an order compelling these document requests as they're listed as topics in his notice, which I don't think is appropriate. I think if he wants documents, he can serve a document request, and then we go through that procedure. If Your Honor, and that's my position, if he wants to request these documents as indicated as topics in the designee notice, then our objections that we discussed over the last few weeks of this argument remain. And if Your Honor is going to enter an order compelling document requests based on these topics, then I'm prepared to argue each topic and present my point. But we don't, like I said, we don't have any issues on two of the topics. But our position is, Plaintiffs' Counsel has requested designee since June. And obviously this motion was denied as moot. 4 months later, they file another motion. We've been here a few weeks trying to get it resolved. And then this morning they say, oh, well, we'll do a document request. I would just say to that, serve a document request.
Mr. Craig, in the notice, the most recent notice, not the one that you did in the spring, but the one that you did a few weeks ago, not the one you revised last Wednesday, was there along with the deposition or the corporate designee notice, was there a request for that designee to provide documents as well?
There was, Your Honor, and that's exact to defense counsel's point. This is a notice that we originally sent back in the spring. And in our revised notice, with each topic, not only is there the request for the testimony, but there's also the request for the production of the related documents.
Yeah, so I think
go ahead.
So, Mr. Mulligan, I agree with you that if there is no previous request for documents contained in the deposition notice, then I would suggest to Mr. Craig that he sends something out separate, and then you can respond. But given the fact that it's teed up, then I'd like to address what objections you have on the document productions that he's looking for.
Okay, that's fair.
Now, do you want to go through with it line by line, or do you want to try and work it out? It's up to you.
I don't think we can work it out because we've already discussed our issues with counsel regarding the designee notice. The issues, I don't think Your Honor or Pete have copies of the revised notice that we utilized last week. So I would be going off of that revised notice, not the notice that's in the order or in the motion.
And Your Honor, I'm happy to send the revised notice as it stands.
Okay. So what's the first objection that you have, Mr. Mulligan?
Okay, if we want to go through each single one. So their first requests asks for.
Let me just put how many requests are there?
There are.
I believe it's 15.
Yeah, 15 requests.
We're going to go through all 15?
Yes, we had objections on each single
That's
one.
fine. But let me just put you on hold. Pete,
Yeah.
do we want to take other cases ahead of them and not?
We can do that, Your Honor, absolutely.
Yeah, let's do that. So let's
Okay.
just put you
We'll
on
recall
hold.
case number 17.
Yep.
Counsel, if you want to go back into the breakout room to try to work it out.
They're not going to work. I don't think they're going to work it out. You can certainly do it. I just don't want to go through 50, spend half an hour with everybody else sitting there.
Of course.
Appreciate that, Your Honor.
Yep.
All right, next case, Your Honor, is going to be case number 3 and 4. Carter versus Clinical Practices of the University of Penn. Case number 3 and 4. I think I may have Kevin. Yeah, there we are. Okay, I'm going to ask the plaintiff to identify themselves for the record and who they represent.
Stephen Speck for plaintiffs Wayne Carter and Mary Ann Carter.
Going to ask the defendants to identify themselves for the record and who they represent.
Morning, Your Honor. Tom Savon for the Penn defendants.
Kevin Riley for Post Acute Partners LLC, doing business as Good Shepherd Penn Partners.
Is this relating to venue discovery, or what's the discovery that you're seeking, Mr. Specht?
So this is actually on your rule with regards to their defendant's preliminary objections to the issue of service.
Okay. And so, Mr. Savon, what's the objection that you're standing on?
Sure, Your Honor. Actually, it's our motion for a protective order.
Oh, I'm sorry. Okay.
And Your Honor, we had filed POs as to the issue of service.
Yep.
Plaintiff's counsel responds as to referencing contacts with Good Shepherd. Your Honor then issues this rule to show cause. Plaintiff's counsel then notices the depositions. We file the motion for protective order, and what plaintiff then references, or what plaintiff then does, plaintiff's counsel, is he files an affidavit. And what he says in there is he was nothing as to Good Shepherd. There's a lot as to Good Shepherd in there, but I'm not going to refer to any of that. But with regard to Penn defendants, he simply says he was led to believe issues as to service, that he didn't have to reserve the writ. But Your Honor, it's absolutely devoid of any factual predicate. Doesn't mention anything. However, what he does mention in there.
But let me just, is there some representation that counsel agreed to accept service on behalf of Penn?
No, Your Honor. As a matter of fact, in counsel's affidavit 15C, he says that Penn specifically told him that just to simply file the writ to preserve the statute of limitations. So there obviously was no tolling statute, Your Honor, or tolling agreement. I apologize.
All right. So, Mr. Specht, what are you seeking to obtain?
So the purpose of the depositions would be the basis that we had this conversation and that there was an agreement between the parties, or between counsel for the parties, that service was not required. While
who is the agreement with?
In-house counsel for both defendants.
Who?
Oh, Jennifer Reno and Georgina Alexa.
All right. When did these conversations occur?
So
memorialized in some way, or
no? They occurred on January 10th of 2022.
All right. And is this in some way, again, I please understand that I don't look at anything until issues are not able to be properly or issues are not able to be agreed to. So, Mr. Savon, you're saying that in his response to the preliminary objections, he identified, just put it forth again.
So sure, Your Honor. There was no agreement with counsel with regard to filing the writ. None. As a matter of fact, plaintiff's counsel actually says in 15 paragraph C, his affidavit, that his conversation with Ms. Reno was that he was to file the writ to preserve the statute of limitations. Those are I think, essentially the words used. So there was no tolling agreement. Plaintiff's counsel nowhere else in his affidavit talks about any specifics as to the Penn defendants. It's important to break this out between the Penn defendants and the Good Shepherd defendants, because he does make representations as to the Good Shepherd defendants. He makes none as to the Penn defendants. As a matter of fact, the only thing he actually references says the exact opposite of what he just represented.
All right. So, and Ms. Reno represents who?
Ms. Reno is in-house counsel, Your Honor, for Penn. She would be involved, before the case is sent out to outside counsel.
Yeah, so I think, Mr. Speck, my suggestion would be is that if you provide, because I could, these Zoom calls are not necessarily the best to gauge reaction, but I could tell that Mr. Savan was surprised at the detail that you were going through in terms of what conversations may have occurred between Penn in-house counsel and yourself. So I think you're going to have to plead something specific as to Penn that would then lay the foundation to then for me to order a deposition of these in-house counsel.
And when you say plead, Your Honor, what do you mean?
Well, when you file preliminary objections, I'm sorry, when Mr. Savan provides preliminary objections, you file a response to them. And in those responses, you make averments that then create issues of fact that the court can then decide. And Mr. Savan is pointing out that in your responses, you haven't created an issue of fact as to whether there was some agreement with Penn.
So Your Honors, you want plaintiffs to amend their answer to the preliminary objections?
I can't give you legal advice, but what Mr. Savan is representing in terms of the statements that you believe have occurred and the conversation that says, and I'm not going to quote it because I don't have it in front of me, essentially go file this where there's no agreement, that doesn't create an issue of fact as to whether there was an agreement. Certainly what you have represented to me indicates, at least from your perspective, that there was an agreement. That all needs to be contained in, at least in my view, a verified response to the preliminary objections.
Okay, Your Honor. Can I just take a step back? How do we address the actual statute of limitation issue that would make all of this motion practice unnecessary?
When's the statute? When was the injury claimed?
So we actually stated in our amended complaint that, the statute of limitations, plaintiffs learned of the causation of the injury as of May 19th. Service of
2022?
Of 2020.
Okay.
And that the reinstated writ was filed on May 10th, served on all defendants on May 10th of 2022.
Yeah, I don't want to get ahead of myself in terms of preemptively deciding issues that are not raised. So I don't want to enter is the protective order simply just as these depositions and nothing further, Mr. Savan?
Yes, Your Honor. It's just for the depositions, and that's all we're asking for. An affidavit where counsel represents what was said. As of right now, there isn't anything.
Yeah. So I would suggest that if Mr. Speck puts in a pleading or an affidavit or something that creates a basis to order these depositions,
then
that will be provided, and
Your Honor,
I assume we'll agree to them. Or if the defendants open the door by submitting their own affidavits, then that's provided in the order that he's presented. Go ahead, Mr. Speck.
Your Honor, I filed an affidavit on the 12th of October, laying out the conversations, which is what Mr. Savone is citing to.
All right. So where is there? Does it say that the Penn defendants agreed to accept service?
It specifically reads, as he cited in 15C. We discussed. Remember, this is a site tolling agreement, and Ms. Reno indicated that the underside should, quote, just file the writ to preserve the statute, quote, end quote, and led the undersigned to believe service of the writ of summons was not necessary while counsel for defendant reviewed the settlement package.
I don't read that at all to say that there's some agreement to either toll or accept service. It's instructing you to file the writ. And what you believe is that's your belief, but that you're not telling me that there's anything, at least from there, that would make that belief reasonable. So I'm going to sign the order as it was presented by the Penn defendants. And if you come back, I may have to make a special appearance, but I am hanging on to all the rules. So for example, this rule, although I will not be the team leader for 2022, I am hanging on to all of these rules and will decide them as they become ripe. Anything else to add?
No,
Well,
Your Honor. Thank you.
All right, good luck.
Your Honor, real quick,
Of course.
The motion to compel also includes the deposition of Georgina Alexa, who is in-house counsel for co-defendant Good Shepherd. She has filed an affidavit, but the day before, about 5:30, the day before her deposition, her counsel indicated in an email that Ms. Alexa would not be presented because Mr. Speck is also a witness and cannot depose his client because it may create a conflict.
I see the names as Conroy, Reno, and Van Tristy.
Those are the Penn individuals, Your Honor.
There's two motions here, Your Honor.
I see. I only saw one of them. So
There's a motion to compel as well.
Yeah, Your Honor, the Georgina Lexi is essentially, she's the in-house counsel for Good Shepherd, and then we are representing Good Shepherd as well.
Pete, is that on today's list? I'm not finding it in the list of.
Yes, Your Honor, there's two. It's case number 3 and 4. There's two control numbers. Control numbers 22103282 and 22101240.
Oh, I see. I guess I don't have a response to it. So is this now Mr. Riley to step in?
Yeah, I mean, we didn't respond to this because we were waiting for the November 16th. This was my colleague Ken Powell responded just via email along the way, just citing that because of the affidavit it created just a conflict of interest, and we thought it would just be resolved by you.
So is there another motion that's pending as to whether there's a conflict or no?
No.
What are you waiting for November 16th? I didn't follow you.
I think that was your motion on the your order for the issue of service. I think that was the last thing.
I think counsel's referring to the supplemental briefs that are due.
Oh, okay.
In the preliminary objections to show cause why the preliminary objection should not be.
Okay, I'm looking at is it the control number that ends in 3282, Mr. Speck? Is that what you're looking at?
Yes, Your Honor.
Okay, and again, I'm looking at, that's your motion to compel. Oh, Alexa, I see. All right, so, and Georgine Alexa, she submitted an affidavit or made representations as to service?
She has submitted an affidavit, Your Honor.
And the affidavit says what? That she did not accept service?
That's correct, Your Honor.
Yeah, then I think Mr. Speck is entitled to her deposition. Limited to the issues submitted in her affidavit. Okay.
Okay, Your Honor. Yeah.
All right. So I think as to second one, 3282, I'll just strike off the names of Conroy, Reno, and Venestrici, and just order that. Can you do it within 10 days, Mr. Riley, or how much time do you need?
I think I would need to double check with her. It could be within 20. I think sure I should be able to.
Yeah, and if you need the deadline moved out on.
Well, Your Honor, I'm going to ask for that. I don't know what Mr. Savant's position is on it as well, but the November 15th deadline, given if we're going to have to amend a answer and conduct the depositions and possibly be back here for another motion to compel, we're going to need some more time on the original.
Yeah, I don't have a problem giving you more time. just make sure that you submit that before the November date. Okay,
Yes, Your Honor.
Very much, Your Honor.
all right, good luck.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you,
Thank you.
counsel. You'll get e-notification of your orders. Thank you.
Thank you.
Next case, Your Honor.
Okay,
Ready?
yep,
Case number 12, 19, and 20. All the same matter, the Walsh matter. 12, 19, and 20. I'm going to ask the plaintiff to identify themselves for the record and who you represent.
Morning, Your Honor. Donna Casasanto on behalf of the plaintiffs, Michael Walsh and Beata Chapman.
all right, hang on. Hang on one second, I need to finish what I am writing. Okay. I'm sorry, Pete, this is which one?
This is 12, 19, and 20. The Walsh matter. I'm going to ask the plaintiff to again identify themselves for the record and who you represent.
Donna Casasanto on behalf of the plaintiffs.
Defendants.
Good morning, Your Honor.
Go ahead, Nick.
Nicholas Kapsamalis on behalf of the defendants Theodore Gainey and American Flower Markets.
Ms. Kim, you lost your video.
I am here. Good morning, Your Honor. My name is Insoo Kim, representing Defendant Handwork.
All right, counsel, we're gonna have to restart this. I had another scheduling issue that somebody thought we were doing something else at 10 o'clock and I had to say no. So, all right, plaintiff counsel, you are who?
Donna Casasanto.
Thank you, Ms. Consanto. And Ms. Insoo Kim.
Defendant Handwork, Your Honor.
Okay. Mr. Cappy Smalls, is that right? Cappy Similis. Bad eyesight right now, so not, it's so small.
Kapsamalis, Your Honor.
Kapsamalis.
On behalf of defendants Gainey and American Flower Markets.
Are you involved in these motions or no?
This first one for number 12, movement in this motion to compel the live deposition testimony of the plaintiffs.
Okay, so you're just involved in 12?
Respondent in 20.
Okay. All right, go ahead, Ms. Casanto.
Well, number 12 is Mr. Kapsamalis's. Are we going to take that one first? That's his motion. And he's requesting a live deposition of the plaintiff. We're opposing that motion because Mr. Walsh had surgery over the summer for lung cancer, which puts him at a compromised risk. And we are requesting that deposition be kept as a Zoom deposition as it was initially noticed. Co-defendant Ms. Kim, co-defendant's counsel Ms. Kim originally noticed that deposition as a Zoom. The defendant's depositions are proceeding by Zoom.
What about Ms. Chapman? Does Ms. Chapman have the same compromised health issue?
Ms. Chapman has a consortium claim, but she does not. No, she is, it's Mr. Walsh who has the compromised health due to his lung cancer.
All right, Mr. Kapasmalis, do you agree that Mr. Walsh has had lung cancer and thankfully is in recovery.
How do you speak to that's the plaintiff's position why he should not be in person? They have submitted that. I'm not saying they're lying. I do believe that being the case. I trust Ms. Casanto.
Okay, so what's the benefit of having them in person versus by Zoom?
It's position that given the high value of the claim damages, we prefer to have these in person. I understand over the course of the last few years, more depositions and hearings have been conducted via Zoom and other remote technologies, but our position is that as things begin to open up more, and just a matter of how depositions, we prefer them to be conducted in person. Again, I have no choice but to believe he might have some heightened health issues, but our office is, in this COVID era, we are fully equipped to handle a large scale room with masks, protections, and just a matter of, going back to depositions in person. We prefer these in persons based on the amount claimed. Amount of claims is over $1 million in damages. And given the high value of that, we feel like we're even more entitled to take these in person.
Yeah, so as to Mr. Walsh, that can occur by Zoom. As to Ms. Chapman, that should appear in person. If you want to keep the dates November 30th or arrange different dates, it's up to you. But that's what I will decide as to Mr. Capsimolis.
There it is.
Is that right? There you go, Capsimolis. As to your first motion, okay?
Yes, Your Honor.
All right. And what's the next? Let me just, can you do a revised order, and that would be helpful. That way I don't have to spend my time revising your orders. And we can go to the next one, which is Ms. Casanto's 2 motions to compel.
Yes, with regard to number 19, our motion against defendant Gary Handwerk, that will be withdrawn. So the next motion would be number 20 against defendants Theodore Gainey and American Flower Markets. And that motion is for deficient discovery responses from those defendants. And we have I have it delineated in the order, the different items of discovery that were deficient. Number 1 being the Erie Insurance Adjuster claim notes, which were not produced. Pursuant to
just hang on a second. So is this Ms. Insuk Kim? Is this your motion or no? Is this?
No, Your Honor, my motion is now withdrawn.
Very good.
Against me is withdrawn.
Terrific. So Mr. Capsimolis, are 1 through 8, are you able to agree to any of those?
With regards to 5 and 6, the subject crash report, I've given counsel the police report, and it's the only crash report I can see in my file here. So I can't give what I do not have. And I've given that police report. A copy of the driver's license. I don't really have an objection as to the driver's license. These depositions are actually scheduled to take place in the coming weeks, and I feel that can be produced at that time without issue. Regarding the maintenance records and invoice and anything regarding property damage and repair, we don't have a property damage claim. So anything regarding the vehicle in which my client was driving at the time regarding maintenance inspection, I feel is irrelevant and inappropriate here.
All right, so let's go in the order. The claims notes and claims log. What's your objection to number 1?
Overbroad, we've given all discoverable and relevant documents from the claims file, including recorded statements, declarations pages showing the insurance, and others.
Have you listed something as being withheld based upon a privilege? Overbroad is not going to work. You're going to have some privilege that you think exists in there.
In terms of irrelevance to the claim, we've given all discoverable and possible work product privileges.
I mean, I would, Ms. Casanto, what's the relevancy of the maintenance records and other records that you're seeking to obtain?
Well, are we talking about still the claim number
No,
one?
let's go to number 2. Go ahead.
Number two, interrogatories number 11 and 15, asking for those items, the maintenance records and invoices. The responses given by defendant was to be provided. So,
But he's saying that there's no property damage there, that claim, therefore you don't get them. What's your response to that?
well, there's no property damage claim, so the vehicle wasn't repaired. Is that what he's saying? That there was no repair to the vehicle? Also, this is
I would think that your response is that maintenance records would go to whether there's a claim of negligence.
absolutely. And that's something that certainly we'd be entitled to and would show if there was any problem with this vehicle that may have contributed to the collision.
How did the accident occur in your view, Ms. Consento?
This was a rear end accident that Mr. Gainey struck the rear of the plaintiff's vehicle.
All right. And is there some allegation that the brakes weren't working, or that some other part of the car or truck or whatever the vehicle was not properly maintained? Is it in your complaint?
That's what I'm looking at right now. It does look like it was. There is a punitive damage claim against those defendants.
If it's operator error, then I don't think you get them. If it's some claim of negligence relating to the maintenance of the vehicle that you've put in your complaint, then you would get them. So if you're not identifying something in the complaint that would say that there was more than operating error, that he failed to pay attention, failed to maintain a proper speed, safe distance, all those other things, then I will, at least as the number 2, I thought I was going to back into number 1 by pointing out number 2, but as to number 2, I would strike the maintenance records and invoices. I don't see a reason to provide them. The claims adjuster's notes and logs, you should provide those unless there's some privilege that attaches and you think that there's some mental impressions or thoughts that would go to the value or the merits or the legal strategy. I don't know what the interrogatories 25 and 52D are. What's the topic of those?
Number 25 is asking Mr. Gainey what his itinerary was that day, where he was going, where he was coming from. And the response to that was to see his recorded statement, but that information is not contained in the recorded statement. With regard to
yeah, go ahead.
With regard to 52D, that was asking his cell phone information, specifically his cell phone number. And there is a claim of cell phone usage that contributed to this collision.
All right. So again, Mr. Kapsamalis, what's the objection as to 25 and 52D?
25 it speaks to, again, with relevance, his itinerary at the day does not say what he was doing in the moments leading up to and the moments leading immediately after the subject incident. So where he started on the roads is irrelevant. And again, we have provided his recorded statement, and counsel is free to pose him as to all these issues at the deposition in the coming weeks. With regard to 52D, his cell phone number, that's confidential contact information, and again, irrelevant to the claim if he has a cell phone.
All right. So as to both of those objections, I will overrule both as to 25 and 52D. So keeping track, one is you're going to be required to have produce number 1, subject to a privilege log. Number 2, you do not require to be produced. Number 3, you will be required to produce. Number 4, property damage and repair documents. That, in my view, would go to the extent of injury that may be provable either by the damage of your vehicle or the damage of the plaintiff's vehicle. Number 5, I think that you have produced that. Number 6, you're going to produce at the deposition. Number 7, what's a DL 503 form?
That's to get Mr. Gainey's driving history record. And the relevance of that is that he is employed by American Flowers. So, and there's a negligent entrustment claim. So we're entitled to see what his driving history is and whether he should have even been driving for that employer.
Go ahead, Mr. Capsamalis.
In a supplemental list of discovery, we produced the employment file of Mr. Gainey, the employment handbook, his job description, and also, even though I would argue that prior accidents do not speak to what happened in this one, he was involved in a prior, which was produced in that supplemental discovery. There's an email thread between his employer and adjusters speaking about it. That was produced.
Yeah, she's asking for the driver's history. So I'm going to order that you provide a signed DL 503 so she can understand what the prior driving history was for Mr. Gainey. And then what's number 8, the Bates stamped 82-097?
That appears to be emails amongst American Flowers. And there's redactions in there. So I don't have a privilege log. I don't know what the nature of those redactions is. So I can't tell if they're proper redactions or not. But there's several redactions throughout that whole Bates stamped 82 through 97.
All right. So Mr. Capsamalis, what's your thoughts on number 8?
Understood. If she's just looking for the log, that could be supplied. Kind of speaking freely here, had to deal with the value of the claims and other things, but if that just needs to be submitted formally, we could produce that.
All right, so it's the value of the value or merit of the underlying litigation.
Yes.
All right. Why don't you just put that in a privilege log, and if you can submit a revised order, Ms. Casanto, run it by Mr. Capsamalis. Is there anything else you want to talk about today?
No, Your Honor, I think that covers our motion.
All right. Good luck. Nice to see you both.
Okay, thank you. Thank you, Your Honor.
And nice to see you, Ms. Insuk Kim.
Thank you. Have a good day, Your Honor.
All right, you too. All right, last but not least, we're back to McDonald's. Pete, you're on mute.
Read my lips though, right, counsel? Apparently not. Okay, counsel, move it. Identify yourself for the record and who you represent.
Good morning, Your Honor. Daniel Craig on behalf of the plaintiff and movement, Mr. McDonald.
Respondent.
Daniel Mulligan on behalf of respondent defendant Amtrak.
Pete, can they share their screens or no?
Yes, Your Honor, they have the capability.
All right. Do you want to go through, we'll go 1 through 15 or whatever the numbers
Your
are?
Honor, I also did email you the revised notice. I think that was sent to me. I just emailed it to you.
I'm also happy to share my screen, Your Honor.
Sure. Let's, well, let me just print it out and then I will be able to make some notes. Apparently Pete thinks that I check my email while I'm doing these discovery hearings. I might check the Eagles score or the Phillies, but they don't play that early.
Plenty of time, Your Honor.
Plenty of time. All right, so Number one. Let's see here.
Yes, I guess, Your Honor, since I'm the one with the objections to each one, you just want me to go through each one?
Sure.
Okay. So request number one asks for the existence description, nature, content, custody, and I'll skip over some of the less important words. Backup and format of records and documents regarding plaintiff Gerard McDonald and the incident issue, including description of any information and or document management system. This includes any records, reports, memorandums, notes, emails, etc. that concern Gerard McDonald and or contain facts or opinions regarding concerning the claims and allegations in the complaint. And then there's the request for documents. And just to clarify what we're arguing here, plaintiff's counsel and I have agreed regarding the designee topics. There's two of them, but I'm addressing these topics solely for the purposes of a document production. I'm no longer talking about a designee anymore.
Is there some definition of what the incident at issue is?
I mean, I'm aware of what the incident at issue is. I believe there is. Let me see.
So what's the
well, the issue is I tried to narrow the topic through red lines, which I don't think they're included in the copy I sent you, but I tried to narrow it so that it would, the way it reads, it says Gerard McDonald and the incident at issue. I redlined it to make it more specific that it would only relate to the incident at issue, and plaintiff's counsel disagreed with that limitation. They essentially wanted, based on the reading of this, they wanted a designee initially and now documents, any documents relating to Gerard McDonald in his entirety employment at Amtrak.
And Your Honor, if I may, any documents relating to the plaintiff in this litigation are relevant. You know, if it's limited to the incident issue, that would preclude, you know, any job safety training he had received, any previous job briefings, any similar incidents on the job he had where he was injured. You know, put frankly, any documents in the possession of Amtrak that relate to our plaintiff are relevant to the litigation.
And that's so overbroad. There's payroll.
Just hang a second. If he was penalized for smoking in an area that he should not have been smoking, right? Or chewing gum in an area that he should not have been chewing gum. This, as worded, would require Amtrak to produce those documents, not in any way relevant to the litigation. So I think you can get, I would agree with you, if there was training material that was provided, if there were prior issues, but his work application may be relevant, but I think I would endorse the more narrow, that it's anything relating to Mr. McDonald. I'm sorry, what did you say, Mr. Mulligan?
As I had edited it to as it relates to the incident issue, so that it's limited to the incident issue and rather than Gerard McDonald and or the incident issue.
Yeah, and then your second sentence, that this includes any records, reports, memorandums concerning the claims and allegations in the complaint. And those claims and allegations reach to training, education, safety, all of the things that you're looking for as it relates to the claims at issue.
I understand that, Your Honor. I would just ask that some specific language be added to this topic then, so that it incorporates that. Because what my concern would be is that
you can do that. Mr. Mulligan is he will. I think if you can speak freely, Mr. Mulligan, if there are things that you are holding back, I mean, I don't know what they would be, but one would think that this is not a significant document production, right?
No, and I think we've already gone through one series of document productions, and that was our issue. I think we already produced his personnel file, his training Excel spreadsheet, his job application. There's payroll documents in the personnel file that we produced already months ago, but there was no request for witness depositions after that moment. So frankly, this might have been covered already. I was addressing my objections were originally for the designee notice, but I still don't want an order entered without the limitations I'm arguing.
But if I endorse, which I am, your prefatory language about it relating to the incident at issue, then do you have other objections? And then Mr. Craig may add in some more, I won't call it surplusage, but more specific language as to what he really is looking for. Do you have any objections then as to the different objections on 2 through 15?
I had different objections to each single topic.
All right. Then
Yeah,
let's
so
go.
I can make our objections to point number 2 were the same objections to point number 1. It read regarding emails regarding Gerard McDonald and the incident issue.
I
and
know, but I just strike that out. I am endorsing your limitation.
Yeah, okay.
Do you have any other objection as to number 2?
No.
And Mr. Craig may add some more language to it, all of which will be specific to allegations in the complaint.
Mm-hmm.
Right, Mr. Craig, you might do that, you might not do it, but
Yes, I would prefer to do that. Thank you, Your Honor.
okay. So let's go to number 3 then.
Number 3 was the same limitations.
Okay, so same issue, number 4.
I don't think we had any objections to number 4 as it relates to a document request.
All right, number 5.
No objections to that request either. It was already limited to the incident issue.
Number 6.
Number 6, it reads training materials related to job safety, job assignments, ergonomics,
I'm sorry,
and risk.
Counsel, I apologize. If you read that too fast,
Yeah,
if you could
I
slow down.
apologize.
When you read, you tend to read more quickly than you speak. So Ms. Veneri needs to follow along. So go ahead from the top.
Number
Job safety.
6, request training materials related to job safety, job assignments, ergonomics, and/or risk management. We saw that as very broad. I attempted to limit it to specifically as relates to lifting techniques, which is how plaintiff injured himself. He was lifting a backhoe bucket. If we read the request as it stands as number 6, training materials, job safety, job assignments, incredibly broad. Job safety alone, not to mention this isn't limited to the incident at issue or plaintiff at issue. This was directed to all at Amtrak, which this would just be an incredibly over-encompassing request. Any document that Amtrak
just
would
hang a
ever have
second.
related to all of this.
Mr. Craig, if it's limited to lifting, I don't know if I'd say lifting technique, but why don't you say heavy machinery or heavy vehicle equipment?
Yes, Your Honor,
including-
actually.
What's that?
If I may, Your Honor, actually, when I was going back and forth with emails with counsel about this topic, I actually offered to limit this to the subparagraphs listed in paragraph 9, which outline much more specific types of training materials.
Yeah.
If we're willing to limit it to the subparagraphs in paragraph 9, where we actually do delineate and specify, then I'm happy to do that.
Yeah, I was going to go back to number 4 and looking at your backhoe and pickup truck and relating to the transportation, acceptance, delivery, loading, unloading. But if you want to move forward to number 9, do you have an objection to number 9?
Yeah, we were okay with number 9, most of it, except for subparagraph G, where it says risk management and/or ergonomic study related and/or pertaining to proper and safe manual labor. We again saw that as really overly broad, and considering it's directed to all of Amtrak, I don't even know what that, I know what that means, but I limited it to specifically related to lifting techniques.
I think lifting, loading, unloading, I mean, I think lifting might be a little more too narrow, but lifting, unloading, loading.
I'm okay with that. It was too broad. Safe manual labor could be.
You may also want to
anything.
add in moving. I think that moving is probably also fair.
Yeah.
And Your Honor, to be clear, we actually Dan, correct me if I'm wrong, we actually agreed on that revision. So if we want, I would be willing to add that language as I have it here regarding to lifting, unloading, loading, and moving heavy materials. And then I would take these subparagraphs and add them to paragraph 6, if that's okay with you.
Yeah, that should be fine with me. Yeah, the only issue I had with 9, I think that was actually an issue we raised back in April, frankly, was just that subparagraph G. But if it's clarified with all the words you just used, I don't have a problem with that.
All right, so how about number 7?
7 is incredibly broad as well. It asks for any complaints, written or verbal, regarding lifting, loading, injuries that occur 3 years prior, 1 year following, but it doesn't limit it to any sort of scope or geographic area. As it's written, it applies to all of Amtrak, which is 20,000 employees across the entire nation. I tried to limit it in geographic area to Amtrak's Keystone line, which is from Philadelphia, Pennsylvania to Harrisburg. This incident occurred, I believe, in Paoli. And I also want to limit it in some way to craft. And you can have, a secretary in an office lift up a box that's too heavy and she's hurt. We have, red cap.
I wouldn't read it that, I mean.
I'm reading it
you're
as
talking
it's
about-
served, and there was an order about to be entered on this designee notice. So I'm just.
Your Honor, if I may, simply put, if an Amtrak employee is injured in the exact same way in, let's say, Washington or California, that goes directly to Amtrak's notice as to
Yeah,
these.
no, just, I think the issue is, if it's an injury sustained by employees tasked with manually lifting objects, that's the focus. I agree with Mr. Craig that if someone from California or Texas or somebody else is injured with a lifting backhoe bucket, or similar, kind of similarly weighted containers, that I think would be relevant, because that goes to notice of the issue, and ultimately it probably won't come in. It's one of those things. If there's 5,000 of those incidents, then we can talk about maybe narrowing it to a much smaller window of period of time. If there's 10 incidents in the 3 years before and 1 year after, then I think you should produce all 10. But we're not talking about a secretary lifting a box. And so the language "and injury sustained by employees tasked with manually lifting objects," I would strike that, Mr. Craig, and limit it just to,
could we say something like along plaintiff's similar craft and or job title?
I would narrow it to verbal and written and verbal complaints relating to injuries of employees, because I think it has to be not that, well, it's not only injuries, but also concerns about safety or risk, that they're doing it, that this is unsafe. How we're loading this is unsafe. Maybe they didn't get injured, but they thought it was potentially unsafe. I think you can work out all these together. I really don't want to spend much more of my time doing this, because I think you can be, if you're reasonable, and you have been reasonable, but this is the type of kind of negotiated language, clear language, that I think you can work out hopefully amongst yourselves. The goal is to get, is to not geographically limit the, if someone's injured in the same exact way and they're in California, then Amtrak is on notice of that. And it doesn't matter whether it's in, 100-mile radius of Paoli.
Okay.
But I would say it's not the written and verbal complaints made by employees, including, but specifically, but not limited to, that's so broad, Mr. Craig, that it really is asking Amtrak to do an unreasonable search. If you write it in the sense that it's written and verbal complaints about the safe conduct or the safety issues, then that I think narrows it to Mr. Mulligan, and he's not concerned about the secretary that's lifting some, box. And I would also make it, I think you already have the incident accident self-report. So that would be my thought, is that it's complaints relating to fill in the blank safety issues.
Okay.
And take out the last part, "and injury sustained by employees tasked with manually lifting objects."
Yeah.
And it's not reasonable, Mr. Mulligan, to stand on some geographic limitation. The years are fine for me, 3 years, 1 before and 1 year after, but the geographic limitation is not reasonable.
Okay. Understood, Your Honor. So you're suggesting we take out that last section about tasks with manually lifting?
Yeah, I don't think that gets you anywhere.
And written and verbal complaints about safety issues and or injuries
Well,
concerning.
now that I'm looking at, the injuries are covered by paragraph 8.
Correct.
So when you're saying you want verbal complaints, it's not, it's just, someone could just be complaining about, I don't like to do my job, but this is what I'm supposed to be doing.
Understood.
It's complaints about safety.
And or injuries.
Yeah. All right. Number 8 is the accident report. Do you have issues with number 8?
The same issues that we had with number 7, we had with number 8. So I think if we limit it, I suggested the geographic scope. These are just asking for like incident reports from what we just previously talked about. So I think if we were to limit it in the same language that we just discussed, I would not have an objection.
Okay.
I think if we do 3 years prior and 1 year following.
I was going to suggest 3 and 1 just to be consistent.
Yeah, that's right.
And if Mr. Craig wants to come back and ask for more, then you can negotiate whether there's more needed.
Okay.
Number 9, I think we covered. Number 10, what's your issue with number 10? You want it, is it pertaining to lifting heavy materials?
This was actually a topic that I guess this is one of the designee topics that Mr. Craig and I agreed upon for presenting a corporate designee. I had no issues with this topic, but if you want to, Dan, still include it in a document request to us.
Yeah, the way it's phrased is it's still a document request anyway. So we're still requesting the documents, and then we will still require the corporate designee testimony on this topic.
Yeah. So I didn't have any
agreement on that.
And I think really these documents, it's pretty duplicative of the prior requests for like training documents on safety and lifting and all that.
All right. So how about 11, 12?
I guess, yeah, I mean, I don't have 11 and 12. I don't have issues with it as they're phrased more. These are ones that are more phrased as a designee, less so than a document request. I don't have issues as they're phrased as document requests. I'll see if I can find if Amtrak has its document retention policy or information about an employment file system like iterated down. But I don't have issues as a document request with these.
All right. How about 13?
13. This was another one that Dan and I agreed to present a designee on, but I don't have issues as stated as a document request.
All right. Number 14?
I don't have issues with it as a document request.
And 15?
I don't have issues with it as a document request.
Okay. Anything else you want me to run through today?
I think Dan was still wanting an order on the designee, Dan, or do we want to figure that out separately?
I would prefer an order considering the length of time we've trying to get this. Judge, would you prefer that we work out the order for you, or are you going to issue an order on your own?
No, why don't you work out an order and revise it, draft it, and see if you can both agree on it. I hope you do, and make sure you submit it. I am, let's go off the record now.
Yeah.
Essentially, I'm here through Friday. If you don't get me by Friday, it will be a while before, well, if it's agreed to, I think then we could just stamp it, but make sure you get that done by this Friday.
And Your Honor, just to make sure we're consistent with, because I understand you want us to work on it, but I want to make sure we're consistent with your ruling. So defense counsel and I are bickering back and forth about the language. So topics 1 through 3 regarding plaintiff, it's limited to the incident at issue, but you're permitting us to include some language that this includes job safety, training, anything related that would be related to the incident at issue prior to the incident. My understanding as well is topic 6 will be limited to the subparagraphs we limited in subparagraph 9.
Yep.
And topics 7 through 8, there will be no geographic limitation. The limitation in time is 3 years prior and 1 year after. However, these will be related to safety And that will be the specific limitation, is that the incidents or complaints will be related to safety.
And you're gonna strike the injury sustained by employees tasked with manually lifting objects.
And we'll strike that language, yes.
Okay.
Okay, that's, I just wanted to clarify that so that, I don't want Dan and I to be going back and forth unnecessarily.
I don't want you going back and forth.
So the
Mr.
order,
Mulligan's clients need to save all that money and you need to save your time.
exactly. So I just want some clarification. So there will, I guess it'll be one order or maybe two orders, Dan, one order by agreement for the designee, and then another order just saying you're serving these document requests on us pursuant to the rules of civil procedure, something like that.
I mean, I would prefer an order for production.
I
Okay.
think that, so when's the depositions? When are you doing the depositions?
I
think we agreed. The problem is we have a December 3rd discovery deadline. I think we agreed to produce a date within 30 days when Dan and I spoke.
So he's going to need, Mr. Craig doesn't want to reissue document requests and lose the benefit of the time.
Yeah.
So if you need 10 days or 20 days, that's fine. But I don't think we need, just be reasonable in how much time you need to.
Of course, I think the searches, I'll have to talk to my client. I think the searches for all the other, the prior safety issues and lifting might take some time. I know what the topics are, so I can reach out to my client right away and give them a heads up as to what's coming. And I hope that, if the search through the entire Amtrak system for these various incidents nationwide takes some time, I would hope Mr. Craig is understanding in that.
Yeah, I
that
think
is the largest request.
I think 30 days is reasonable. And obviously, Dan, if you truly need an extension, I'm happy to give a professional courtesy. And I think, if we get close to the deadline here, of course, we can always motion for extraordinary relief. So I think 30 days is appropriate if Your Honor agrees.
You're going to spend the next few decades together working on these issues, like your forefathers have.
the Dans ahead of us have.
The Dans ahead of us who have caved.
So that's what I'll say. So, all right. Anything else that you need from me?
No, we will work on the revised order and we'll send to Your Honor's chambers for review.
Send it to Pete just so he can take a look at it, and then he'll forward it on to me. Okay.
Okay. Thank you, Your Honor.
All right.
Thank you,
Good luck.
Thank
Nice
you for
to
your
see
time on this one. Thank you.
No problem.
Thank you, counsel. Just get that order over to me and we'll get it down to the judge for review. Thank you.
Dan, I'll email it. Dan, I'll work on it and I'll email it to you so we can send it.
Of course.
Your Honor, that concludes your discovery list. Can I adjourn court?
Of course, Ms. Veneri, nice to see you.
Court is adjourned on the
Thanks,
call.
Judge.